Good afternoon. My name is Michael Kane. I'm a patent attorney and I'm a principal of Davies Collison Cave. I practice in the area of pharmaceutical patents, and this afternoon I'm going to give you a brief overview of Australia's patent term extension provisions. These were introduced in 1999 to provide pharmaceutical patent owners with additional term to compensate for the term lost through the time spent carrying out clinical trials. So it's not uncommon for a period of between 12 to 15 years to pass between a patent filing and obtaining marketing approval in Australia. So the net aim of the provisions is to provide a patent owner with an effective term of 15 years. Sometimes a patent owner will get 15 years, sometimes less. So first of all, I'm going to go through the legislation that was introduced in 1999. It hasn't changed much since then. I'm going to cover off some issues of interpretation of that legislation, talk about a few cases, talk briefly about the area of products of recombinant DNA technology or biologics, and then finally talk about some new therapies, new cell therapies that are now eligible for patent term extensions. So the provisions appear in section 70. And to be eligible for patent term extension, the patent must claim and in substance disclose either a pharmaceutical substance per se or a pharmaceutical substance when produced by a process which involves the use of recombinant DNA technology. So as you'll see, as we go through some cases, the words per se are very important and provide a limitation on the sorts of patents that are extendable. Now, the definition of pharmaceutical substance is given there. You'll notice it includes a mixture or a compound of substances. So that means not only does it include active agents, but also compositions and formulations. The other requirement for eligibility is that you must have a product included in the Australian Register of Therapeutic Goods that contains or consists of the pharmaceutical substance that's disclosed and claimed in the patent. And finally, to be able to get an extension of term, you must have been delayed by at least 15 years, at least 5 years from the date you filed your patent to the earliest registration of a product in the Australian Register of Therapeutic Goods. There's a deadline for filing a patent term extension request, and it must be filed within 6 months of the date of inclusion in the register of a relevant product, or 6 months of date of patent grant, whichever date is later. But what's very important is that the patent term extension request must be filed during the normal 20-year term of the patent. It cannot be filed later. Now, calculating the term of the extension, as I said, it's a maximum of 5 years, and with an aim of giving patentees a 15-year effective term. So if it's taken 10 years or more between filing and getting a product registered, then you'll get a 5-year extension. If it's between 5 and 10 years, then the patent will expire 15 years from the date of that registration. So the maximum term of a patent is 25 years. And unlike other systems, for example, the European Supplementary Protection Certificate system, the whole patent is extended. There is a restriction, though, on enforceability during the extended term, that it's only enforceable in relation to human therapeutic uses of the pharmaceutical product. So it doesn't extend to veterinary uses, for example. When the provisions were first introduced in 1999, they introduced what are called springboarding or bowler provisions. They were provisions that allowed generic companies to carry out the work they need to do, the bioequivalency studies, etc., in order to get a generic product approved. And that could be done even during the term of the extended patent. In 2006, the springboarding and bowler provisions were extended beyond extended patents to cover all pharmaceutical patents. So now there is a general exemption from patent infringement for carrying out the activities needed to get a generic product approved for marketing. Now, the provisions in Australia are quite clear and easy to understand compared to the European supplementary protection certificate provisions, but there are still some areas of interpretation that we've needed the Federal Court to help us with. And the first one was whether an application could be filed late. The next one was what is meant by a pharmaceutical substance per se. What restriction do the words per se place on eligibility? What's meant by having something included in the ARTG? Does that include listings as well as registrations in the ARTG? What's meant by in-substance disclosed? So what level of disclosure is required? And also how much of the substance, the pharmaceutical substance, needs to be in the registered goods. So the first case that came before the Federal Court was one involving Boehringer Ingelheim. When the provisions came in, they commenced in January of 1999, but there was a transitional period that gave until July for patent term extension requests to be applied for when a product had already been approved. As you recall, the normal deadline is 6 months from the date of approval, or 6 months from the date of patent grant, but when the provisions first came in, there were some products that had previously been registered. Now, unfortunately for Boehringer Ingelheim, the patent expired 2 weeks before that transitional deadline in July. And so when the patent attorneys went to apply for the extension, the patent had already expired. And the reason it expired was it was a divisional application that had a term that was counted from the date of filing of its parent and not the date of filing of the divisional. And this was overlooked and the request was filed late. They then applied for an extension of time to file the patent term extension request, and it was refused because it is not possible under the provisions to file an extension of term request after the 20-year term has expired. So what they did then, they saw that they had another patent which related to a particular aerosol canister that contained the active agent, and they thought they would try and apply for a patent term extension for that container containing the spray composition. Unfortunately for them, the Federal Court held that an aerosol container containing a spray is not a pharmaceutical substance per se. It's a container with a pharmaceutical substance inside it. And that decision was upheld by the full Federal Court, and they did not get leave to appeal to the High Court. Another case that came before the Patent Office very early on was a case relating to a transdermal patch. A transdermal patch normally has a backing layer and it has the medication in a particular layer, and it gets applied to the skin. And the question here was whether a transdermal patch is a pharmaceutical substance per se. The Patent Office refused the extension of term, and it was refused on the basis that the patch wasn't a mixture of substances or a compound of substances. Now, unfortunately here, the hearing officer interpreted the term compound as meaning a chemical compound requiring chemical bonds between the components. Whereas in the patent term extension legislation, the reference to mixtures and compounds of substances is really referring to the idea of bringing substances together so that it can be administered. So the word compound is actually not used in a chemical bond sense, but in the sense of a compounding pharmacy, bringing substances together for administration. However, it was found that the patch did not satisfy the definition of a pharmaceutical substance, and that was refused. Now, because of the way that it was decided, it became then uncertain whether you could get patent term extensions for capsules or tablets where there was a controlled spatial arrangement of the components. For example, a layered tablet where there's two or more layers of containing active agents. Then we had Pre-J in the Commission of Patents. So in this case, Pre-J tried to get a patent term extension for a patent relating to a method of treatment. The argument was made that because the product only had one particular use being in this method, that the patent should be considered to relate to a pharmaceutical substance per se. That argument was rejected. There was an appeal to the federal court, but again, the extension was refused. We then had a situation where a product, which was a polypeptide, was claimed with reference to the process by which it was made. So the claim didn't refer to the actual substance itself, but referred to a method for making it. Now, in this particular case, it was very difficult to describe the material because the structure of the material was a result of the process by which it was made. And so therefore, in this particular case, it was considered that the claims did relate to a pharmaceutical substance per se, even though the wording of the claim was directed towards a process. So this case demonstrated that you could get a patent term extension for a process if the process is the only reasonable way of describing the product. In this case, there was a broad patent application, so a broad patent granted to Pfizer for a particular class of antifungal agent, I believe. And then later on, they filed a second patent called a selection patent for a very specific species within that broad class called voriconazole. So they got their patent term extension for voriconazole because they had a patent directed to voriconazole. But they then went back to try and get a patent term extension on the broad generic class, on the patent directed towards a broad generic class, on the basis that it claimed and in substance disclosed the pharmaceutical substance. Now, clearly it didn't disclose voriconazole, because if it did, they wouldn't have been able to get their later patent directed towards voriconazole. However, it did broadly encompass voriconazole, and voriconazole was similar to some of the compounds that were described in that earlier patent. So the extension was refused in the Patent Office, but there was an appeal to the Federal Court, and that appeal was allowed on the basis that the in-substance disclosed test is a very generous test and is a lesser requirement than the fair basis test. And so this decision basically held that if the pharmaceutical substance falls within the scope of the claims of an application, then that's enough for it to be in substance disclosed. There doesn't have to be any specific disclosure of the substance in the patent. In the Merck and Arrow case, this related to a patent directed to a metabolite of lovastatin. Now, there was a big patent battle many years ago between Merck and Sandoz relating to the drug lovastatin. Sandoz won that battle. They filed their patent application first, and so Merck had to delete lovastatin from their claims, but they still had a patent directed towards a metabolite of lovastatin. Now, what happened was the patent expired, Sandoz's patent, and Merck's later filed patent was still in force. And so they tried to get an extension of their lovastatin patent that was actually directed, that had claims to the metabolite of lovastatin, on the basis that the lovastatin product, Mevacor, contained as an impurity 0.2% of lovastatin. 0.2% of the metabolite of lovastatin. So the question was whether this Mevacor product contained or consisted of the claimed pharmaceutical substance, whether 0.2% as an impurity was enough. In the end, it was found that it was enough, that the patent term extension provisions don't specify any particular amount of a pharmaceutical substance that needs to be present in a product. And so this patent term extension was allowed. Now, this one concerned a number of patents that were granted to Pfizer relating to a product. The patent term extensions were granted on the basis of the first registrations in the Australian Register of Therapeutic Goods. But what happened, the Commissioner became aware of some earlier export listings that were in the Australian Register of Therapeutic Goods. So these are not marketing approvals, these are approvals to make the product and export it to another country. So the question was whether an export listing is a relevant inclusion in the ARTG for the purpose of activating the patent term extension provisions. And according to this decision, an export listing was sufficient, and therefore, because there was an earlier inclusion, if you like, in the ARTG, the calculation of the patent term had to be based on the earlier inclusion, and in one particular case, that extension was reduced to 0. Interestingly, they couldn't expunge the patent term extension, but what they could do is reduce the term of the extension to 0. So there were appeals, but they were unsuccessful. As I mentioned before, there was that issue with the transdermal patch case as to what constituted a pharmaceutical substance per se when there was some structure to a product. That hearing officer said that if there was a controlled spatial arrangement of the components, then the product was not a pharmaceutical substance. It wasn't a compound or mixture of substances. So in this particular case, there was a bilayer tablet. There was an intermediate release layer and a prolonged release layer in a single tablet. It was rejected initially because it wasn't considered to be a pharmaceutical substance because of the controlled spatial arrangement of the components. However, following a hearing, it was allowed because the hearing officer was convinced that the use of the term compound as it's used in the patent term extension provisions is not in the sense of being a chemical compound, but in the sense of bringing components together for administration, which is how it's used in the pharmaceutical arts. So that patent term extension was allowed. And this brings us to the long-running Alpha Farm, if you like, Lundbeck case. And this is still running, this case. This started, well, this is back in 2008. And it all started because of this decision, which, in my view, was wrongly decided. The patent claimed a particular enantiomer of citalopram, which was the S-citalopram or the plus citalopram. For those who are not chemists out there, enantiomers are mirror images of each other. If you can think of, if you like, your left hand and your right hand, they're mirror images of each other. They're not superimposable. When you have some chemical compounds exist in the form of mirror images of each other. Now, when you normally synthesize or make these compounds, you end up with an equal mixture of the two enantiomers. But what Lundbeck had found was that the particular S enantiomer had better activity and I think reduced side effects relative to the R enantiomer or the minus enantiomer. And so this patent was directed towards the plus enantiomer in the absence, if you like, of the minus enantiomer. And so what they did, they applied for a patent term extension. They got the product Lexapro approved, and that's a product which contains the escitalopram. But there was an attack on that patent term extension based on an earlier registration of Cipramil. Now, Cipramil was an earlier product approved that contained both the plus and the minus enantiomer. So the question was whether the earlier product, the Cipramil, contained or consists of the active agent claimed in the patent under consideration, which was directed towards the plus enantiomer in the absence of the minus enantiomer. So unfortunately for Lundbeck, the federal court held that Cipramil does contain the plus enantiomer. Now, not only did the court make that decision, but they also expunged the patent term extension altogether. Instead of reducing the term from 5 years to 3 years, which would have been the calculation based on the earlier Cipramil registration, they removed all reference to the patent term extension. So there's no opportunity to recalculate. They appealed to the federal court, full federal court, sorry, that was unsuccessful, and leave to appeal to the High Court was refused. So what happened then was Lundbeck had to go back and apply for a new patent term extension based on the Cipramil. Interestingly, the patent that they're trying to extend based on Cipramil does not even cover Cipramil, and this is why it's an unusual decision, because Cipramil was prior art against this patent, but the Patent Office was convinced and the court was convinced that the claims were novel and inventive because there was no teaching or disclosure to separate out the plus and antimer. Nonetheless, this patent, according to the court, was extendable based on Cipramil, provided Lundbeck could get a 10-year extension of time for filing it, because by this stage they're 10 years late in filing the request. In the end, they were able to get their extension of time to file the late request, and ultimately they were granted a shorter extension of term based on Cipramil. And this brings us to the products produced by recombinant DNA technology. As I mentioned at the start, there is a separate provision that deals with these products. So you can actually get patent term extensions for process patents if there's a product of recombinant DNA technology involved. And it's also important to note that the recombinant DNA technology step in the process does not have to be mentioned in the claim. And as I mentioned before, you could also get patent term extensions for processes if that's the only reasonable way to describe the product. I thought I'd give you an example here of a claim which was extendable under both provisions. First of all, it talks about it's the preparation of a vaccine which has got this immunogenic construct. Now, one of the components is produced by recombinant DNA technology. Now, it's actually prepared by a chemical process. So even though this is a chemical process, it's extendable because, well, first of all, this is the only reasonable way of describing this product, because what happens if you make the conjugate vaccine in this way is that it ends up having more immunogenicity than it would have if it was made by the prior art processes. Now, it's not reasonably possible to describe the structure of the construct other than through this method of making it. So it would have been extendable under the pharmaceutical substance per se provisions, and also under the recombinant DNA provisions as well. There's also been a number of cases where patent term extensions have been given for processes for making vaccines, including ones where a protein antigen is combined with an adjuvant. So finally, this brings us to cell products. Now, up until recently, you could not register on the Australian Register of Therapeutic Goods a cell-based product. And if you couldn't register it on the ARTG, then you could not get a patent term extension for it. So it was only in 2018 that it became possible to register a cell-based product. Now, there are sort of definitions about what biological sort of cell-based products are regulated under the ARTG, but importantly, one type of product that is regulated is the CAR T therapy. You may have heard of a product called Kymriah, marketed by Novartis. It's a product where they actually take cells from your body, take them away, modify them, and then they infuse them back into your body. And there are certain cancers that can be treated using this therapy. So the pharmaceutical product is actually the modified cells, and we recently got a patent term extension for Novartis for the product Kymriah, and I imagine, you know, as CAR T therapy becomes more widely available, there would be more and more patent term extensions for these types of cell-based products. And that's all I've got for this evening, so I'd be very happy to answer questions. Thank you.
Hi, I'm Susie Russell, and I'm here with my colleague Paul Dewar to discuss what is referred to as the usual undertaking as to damages, and considerations that should be taken into account when assessing whether or not to give the undertaking. These considerations stem from the recent decision of Justice Nicholas in the Federal Court in the long-running clopidogrel dispute. I'm going to stumble over that word throughout this presentation, I'm sure. In which His Honour determined whether or not the Commonwealth is entitled to claim damages under the usual undertaking, but we'll tell you more about the case shortly. First, let's take a look at the usual undertaking. The form of the usual undertaking is prescribed by the court in a practice note and is usually given in exchange for a preliminary injunction. The preliminary injunction orders will state that the applicant for the injunction undertakes A, to submit such order as the court may consider to be just for the payment of compensation to any person, whether or not that person is a party, affected by the operation of the order or undertaking, and B, to pay compensation to such a person. Now, when we come to the Sanofi case, I note that the usual undertaking in that case referred specifically to persons affected by the operation of Order 1. Order 1 granted the preliminary injunction. The undertaking did not refer to Order 2, and Order 2 was an undertaking offered by Apotex, but it would not seek PBS listing. This is a very important distinction in this case. The usual undertaking is particularly important in pharmaceutical patent cases because of the way the pharmaceutical benefits scheme operates when a first generic product becomes PBS listed. A pharmaceutical product with only one brand in the market will generally be assigned to the F1 formulary, and the pricing of such a product is not subject to generic competition. When a generic brand of the same active molecule is listed, the drug will be allocated to the F2 formulary and will become subject to the provisions of the National Health Act relating to statutory price reductions and price disclosure, most notably an immediate 25% reimbursement reduction. So if a generic supplier is restrained from launching and PBS listing by the operation of a preliminary injunction, and the patent is later found to be invalid, persons affected by the order granting the preliminary injunction will seek compensation under the usual undertaking. As we'll see in the Sanofi case, the Commonwealth may argue that, save for the PI, the generic would have launched, thereby triggering the reductions, and it's entitled to damages based on the difference between the higher reimbursement amount it paid, in fact, during the relevant period and the lower reimbursement it should have paid during that period. The lack of visibility in relation to the PBS price listing process puts innovators in the position where they must act quickly to protect their market, often by seeking a PI to maintain the status quo until a dispute can be resolved. The possibility that the Commonwealth may seek damages pursuant to the usual undertaking is a relevant consideration in relation to seeking and obtaining a PI to prevent generic launch. This is to be contrasted against the Commonwealth's position in relation to reversing the reimbursement reduction in circumstances where a PI is not sought by the innovator, but a final injunction is awarded and the generic is forced to withdraw from the market. While it is in theory possible to reverse the reimbursement reduction, it is not commonly done. So this slide provides a snapshot of the Sanofi case. On the 28th of April 2020, Justice Nicholas handed down the Sanofi decision, and it's the first decision in which the Commonwealth's claim for compensation under the usual undertaking was considered and determined. Justice Nicholas held that the Commonwealth had suffered a compensable loss, but rejected the Commonwealth of Australia's claim for $325 million in damage, finding that the loss did not flow directly from the preliminary injunction. The case turns on its facts, but nevertheless gives guidance regarding the court's approach to such claims for compensation by the Commonwealth. The Commonwealth has filed an appeal and Sanofi has filed a notice of contention. This battle's not over. The appeal will likely be heard later this year or early next year. Having reviewed the relevant authorities, Justice Nicholas found that there were three key questions to be considered in relation to the Commonwealth's claims. 1. Would the relevant loss have been sustained but for the grant of the interlocutory injunction? 2. Did such loss flow directly from the interlocutory injunction? And 3. Could loss of the kind sustained have been foreseen at the time the interlocutory injunction was granted? Now, these next two slides give you some background as to the relevant timeline for the dispute. I would just like to emphasise three key points. Firstly, the patent proceedings were commenced and the relevant preliminary injunction was granted in 2007. Secondly, as I mentioned previously, the usual undertaking as to damages was given in relation to the order restraining Apotex from making an offer of supply. Apotex gave a separate undertaking that it would not apply to list its generic clopidogrel products, I told you, on the PBS, but the usual undertaking did not apply to the Apotex undertaking. And finally, the Commonwealth's claim for damages was commenced in 2018, some 4 years after the matter had been settled between Sanofi and Apotex, and was required to prove that Apotex would have come to the market in the face of very substantial potential liability. Paul will now take you through his honours reasonings on questions 1 and 2, and I'll briefly address question 3 before we offer some final points.
Thanks, Susie. So the first issue considered by the court was causation, and specifically whether or not the Commonwealth was able to demonstrate on the balance of probabilities that Apotex would have come to market in the face of the potential liability that it would have incurred if it had later been found to infringe. And this is known as launching at risk. So in relation to this, the court made it clear that it expects detailed evidence of internal decision-making processes as at the time that the decision was made by the generic, and would expect to hear from the key decision-makers. In that regard, it criticised the Commonwealth for not calling Dr. Sherman, who was the chairman of Apotex at the time. Now, upon reviewing that material provided by the Commonwealth, the court found that Apotex appreciated the very substantial risk that it potentially would incur and had no intention of coming to market in the face of that risk, absent the PI, and in fact was using the undertaking as to damages as a means of effectively having Sanofi underwrite its decision not to launch. So it was in a no worse off and potentially only better off situation. So this is going to prove and did prove and will in future cases prove a substantial hurdle for the Commonwealth, especially in circumstances where the Commonwealth's action is commenced many years after the decision is made and where the generic in question, as was the case with Apotex, no longer had any interest in the Commonwealth's case. So the next issue that was considered by the court was whether or not the loss flowed directly from the PI. So since Warner-Lambert number 3, the court won't order that a generic be precluded from seeking PBS listing per se, because PBS listing itself is not exploitation and therefore not infringement. So it's now common to seek and to be granted an injunction in relevantly the terms set out in the slides, being that the generic is restrained from providing or continuing to provide any assurance of supply in relation to its products for the purpose of obtaining listing pursuant to the PBS. So in his decision, His Honour drew a very clear distinction between, on the one hand, the PI which restrained only supply, and on the other hand, the undertaking provided by Apotex that it wouldn't apply to list on the PBS. And this distinction runs through His Honour's reasons. So you can see at 428, His Honour accepted that the practical effect of the PI was that it prevented Apotex Australia from applying for a PBS listing because it couldn't then guarantee supply and it couldn't supply once it was listed. So in those circumstances, Apotex wouldn't have chosen to have applied for listing and query whether or not that listing would have been accepted by the government in any event. But importantly, His Honour found that the PI did not actually stop Apotex from applying to list. This was prevented by the undertaking provided by Apotex. And it can be seen in His Honour's reasoning that this practical effect was not sufficient for the loss to flow directly from the PI. Instead, His Honour found the loss flowed directly from the undertaking not to apply for PBS listing because the loss flowed from the failure of Apotex, or the inability of Apotex to apply for listing and therefore obtain listing, which in turn would drive the price drop, which would cause the Commonwealth's loss. And so at 443, His Honour's reasoning was that the PI did not directly affect the legal rights, obligations or interests of the Commonwealth. It didn't prevent the Commonwealth from receiving or accepting an application for PBS listing by Apotex Australia. And at most, it prevented Apotex Australia from entering the market at a later time. So His Honour, His Honour contrasted this with the effect of the Apotex undertaking and said that the terms of the PI didn't prevent Apotex Australia from applying, and doing so wouldn't have involved a breach of the interlocutory injunction. The Commonwealth's loss was a natural and direct consequence of Apotex not being able to apply to list, which was the precise conduct to which the undertaking provided by Apotex was directed. And it was this that suggested to His Honour that the Commonwealth's loss was an indirect consequence of the interlocutory injunction and a direct consequence of the undertaking provided by Apotex. So for future cases where the injunction is, as in this case, directed towards supply, the same logic holds good, and there's nothing in His Honour's decision that suggests that removal of the additional feature that was present in this case, namely the undertaking provided by Apotex that it wouldn't apply to list, will affect His Honour's reasoning in relation to future cases. Thanks. I'll pass over to Susie.
The final question for His Honour to consider was whether the loss of the kind sustained could have been foreseen at the time the interlocutory injunction was granted. The Court concluded that the fact that the preliminary injunction did not itself prevent Apotex from taking steps to list its generic products on the PBS did not mean that the loss was not reasonably foreseeable, noting that it was reasonably foreseeable at the time Sanofi applied for the interlocutory injunction that if Apotex Australia was prevented from supplying its clopidogrel products, then it would not make any application to list those products on the PBS for so long as the interlocutory injunction remained in force. Although I found that this was an indirect consequence of the grant of the interlocutory injunction, it was nevertheless a consequence that was reasonably foreseeable at the time the interlocutory injunction was granted. Among other things, Sanofi argued that the loss was not foreseeable because the Commonwealth had never made such an application before, and even though Sanofi had notified the Commonwealth that it intended to commence patent infringement proceedings against Apotex, the Commonwealth did not notify Sanofi that it considered itself adversely affected by the interlocutory injunction. Nevertheless, and no doubt as a result of Sanofi's argument, it's now common practice for the PBAC to send letters notifying parties that the Commonwealth may, in the event that it suffers loss, elect to claim compensation under the usual undertaking as to damages in the event that the relevant patent is ultimately held to be invalid. So what does this mean for future cases? The case found that the Commonwealth's loss is compensable in theory and has therefore not shut the door on further claims by the Commonwealth under the usual undertaking. The standard injunction terms, however, prohibit relevantly supply and offer to supply. It's therefore apparent from the decision that the Commonwealth faces substantial hurdles in relation to any claim under the usual undertaking, including A, the evidentiary difficulties with proving that the generic would have launched at risk, and B, the legal hurdle in demonstrating the loss directly flows from the terms of a preliminary injunction where applying for PBS listing is not expressly prohibited. The judgment has, however, been appealed, as I stated before. Accordingly, there are further acts to play out before the innovators and Commonwealth's rights are finally determined in relation to the usual undertaking as to damages.
Good evening, everyone. My name is Grace O'Connor, and I am an associate in the law group at Davies Collison Cave Law. Today, I'll be giving a quick refresher on the research and regulatory use exemptions under the Patents Act. So I thought I would start with a brief refresher on what generally constitutes infringement under the Patents Act. A patent gives the patent owner the exclusive right during the term of the patent to exploit the invention and to authorise other persons to exploit the invention. So what exactly does it mean to exploit? Where the invention is a product, it means to make, hire, sell, or otherwise dispose of the product, or to offer to make, hire, sell, or otherwise dispose of it, use or import it, or keep it for the purpose of doing any of those things. Where the invention is a method or process, it means to use the method or process or to do any of the things that I just listed in respect of a product resulting from such use. If another person or entity is exploiting a patented invention without the patentee's permission, they're probably infringing the patent. For example, if a company imported a patented drug for the purpose of carrying out a clinical trial necessary to obtain authorization from the Therapeutic Goods Administration, that would ordinarily constitute patent infringement. However, the exemptions that I'm about to discuss, in effect, operate as a defense to infringement. So a good place to start is a reminder of the exemptions that are currently in place. We'll break the exemptions into two categories, being the regulatory use exemptions and the experimental use exemption. The regulatory use exemption in respect to pharmaceutical products is in section 119A of the Patents Act, and it essentially provides that a patent will not be infringed by a person carrying out acts done solely for the purpose of obtaining inclusion of a pharmaceutical product on the Australian Register of Therapeutic Goods, also known as the ARTG. Section 119A of the Act was introduced as an amendment in 2006 and specifically excludes other types of patented products such as medical devices. The exemption relating to non-pharmaceutical products was introduced as Section 119B with the Raising the Bar Act in 2012, and similarly provides that a person will not infringe a patent by carrying out acts done solely for the purposes connected with obtaining regulatory approval to exploit a product, method, or process, whether that be regulatory approval in Australia or overseas. The experimental use exemptions were also introduced with the Raising the Bar Act in 2012, and these are set out in section 119C. This exemption provides that a person can do an act that would infringe a patent if that act is done for experimental purposes relating to the subject matter of the invention. Then come to the question of why these exemptions were introduced by the Australian government. In relation to the experimental regulatory use exemption, the explanatory memorandum to the Raising the Bar Act provides a useful and very detailed account of the rationale for these exemptions. However, the factors that underpin and impact these sorts of policy decisions are obviously very complex, and we won't be seeking to comment or unpack any of those concerns today. However, I would like to highlight some of the high-level factors underlying the introduction of these provisions. As I'm sure most of our guests today are aware, products such as pharmaceuticals and medical devices are required to undergo a regulatory approval process before they can be marketed and sold to consumers. And this process is carried out by the Therapeutic Goods Administration, or the TGA. Whilst not the subject of the presentation today, I also note that there are additional categories of goods, such as veterinary medicines, which are also required to undergo an approval process via agencies such as the APVMA. Now, the explanatory memorandum to the Raising the Bar Act indicates that whilst TGA approval can in some circumstances be obtained in as quickly as 8 weeks, the process can take up to 40 months, most typically sitting in the range of about 12 to 18 months. Now, due to the nature of the material that must be submitted as part of the TGA approval process, seeking regulatory approval for a generic pharmaceutical or medical device can involve taking steps that might infringe the patent protecting the originator product. However, there was concern that if a generic manufacturer is required to wait until after patent expiry before initiating the regulatory approval process, the unintended consequence was a de facto extension of patent term, as the patent owner was effectively enjoying an increased period of market exclusivity whilst its generic competitors obtained regulatory approval. Now, various jurisdictions around the world had, prior to 2006 and 2012, introduced regulatory use exemptions to address this perceived concern of de facto unintended patent term extensions, and these are broadly referred to as springboarding provisions. In relation to the experimental use exemption, the explanatory memorandum in relation to section 119C notes concern in the industry that it was unclear whether certain research activities would infringe patent rights, and that this might tend to discourage researchers from working in certain areas or on certain projects. So it's important to look closely at the wording of each of the provisions to understand exactly how they work. Both of the regulatory use exemptions are really built around the language of exploitation solely for purposes connected with obtaining the relevant regulatory approval. Now, it could be said that this covers a potentially quite broad range of activities, but carried out in a very narrow context. The process of obtaining ARTG registration includes various phases, depending on the product in question, and involves the generation of data going to, for example, the safety, quality, and efficacy of medicines. Whilst there's been no judicial guidance on these provisions, it appears that any activity that's connected with an application for entry onto the ARTG, whether that be in a pre-submission or submission phase, will likely be exempt from a finding of patent infringement. In relation to the experimental use exemptions, the language of the Act has a focus on experimental purposes relating to the subject matter of the patented invention. And helpfully, the Act sets out a non-exhaustive list of the types of activities that would be considered an experimental purpose. These include determining the properties of the invention, determining the scope of a claim relating to the invention, improving or modifying the invention, determining the validity of a patent or of a claim relating to the invention, and determining whether the patent for the invention would be or has been infringed by the doing of an act. So what activity is excluded? The experimental use exemption is not intended to apply where the main purpose of the research activity is to commercialise the invention or to manufacture it for the purpose of sale or use for commercial purposes. The explanatory memorandum provides some additional guidance on this and acknowledges that research is often undertaken for mixed purposes, with the specific examples identified in the EM being a researcher may be contracted and paid to undertake experiments. Research may be conducted with a view to ultimately commercialising the end products of the experimentation, as opposed to commercialising the patented invention. And research may be undertaken with and partially funded by a commercial partner. In each of these circumstances, the exemption should apply as long as the specific acts are undertaken for the predominant purpose of gaining new knowledge or testing a principle or supposition about the invention. That is, as long as the research activity is conducted primarily for the purpose of improving a patented invention, the activity would still be exempt, even if the person had in mind commercialising the improvement in the future. It's also important to note that research carried out for the purpose of testing the commercial demand for a patented product is not an exempt experimental purpose. And finally, on this topic, I just wanted to note that the use of patented research tools is not exempt from infringement. Now, this concept might create a little bit of ambiguity, and we'll have a brief look at a case study in a moment. But essentially, a research tool is something that's used to facilitate an experiment rather than being the subject of an experiment. So over the course of my presentation this evening, I have set out some information relating to what the legislative provisions say and some of the policy logic underpinning those provisions. However, I thought it might be useful to finish off with a quick case study in order to better understand how these provisions actually operate. So in this case study, Party A is carrying out experimentation on improving a pharmaceutical compound administered in aerosol dosage form. Party B owns a patent for a drug delivery device, being an aerosol spray apparatus, and Party C owns a patent for the pharmaceutical compound that Party A is seeking to improve. So in these circumstances, Party A is exempt from infringement in terms of the product patent owned by Party C by virtue of the experimental use exemption in Section 119C of the Act, but it's likely that Party A is infringing the patent owned by Party B. And this is because the Party B patented device would probably be seen by the court as a research tool. The subject matter of the experiments, which is the pharmaceutical compound, doesn't relate to that tool. The experiments are not being carried out on the delivery device. The delivery device is facilitating the experiments. But if we were to change these facts slightly and the experiments being conducted by Party A were for the purpose of obtaining regulatory approval for their version of the compound owned by Party C, it's likely that Party B would also be prevented from obtaining any relief for infringement. As a side note, there is some indication in the explanatory memorandum that the Australian government intended the experimental use exemption to operate as it does in Europe. So although there have not been any Australian judicial decisions on this exemption, it may be that an Australian court would take guidance from European courts in interpreting and applying these provisions. So just to summarise what we've talked about today, the Patents Act does provide for some exemptions for patent infringement in circumstances where a person does an act that would infringe a patent, if that act is done solely for purposes connected with obtaining regulatory approval to exploit a product, method or process, or if the act is done for experimental purposes relating to the subject matter of the invention. The explanatory memorandum to the Raising the Bar Act in particular provides very useful guidance as to how these exemptions operate in practice, although Australian courts are yet to consider these provisions. As a final comment, I just wanted to note that it can be very useful for a patent owner to monitor the ARTG, as the ability of a generic to register prior to patent expiry can operate as a useful warning bell for patentees as to exactly who will be coming into the market immediately upon expiry. This knowledge also means that a patentee can take steps to monitor that generic's activity to ensure that they don't take any steps outside of what the regulatory and experimental use exemptions cover. And it can also be an opportunity for the patentee to write to the relevant generic in order to, in an attempt to obtain some further information about the generic's planned activities. And on this issue in March this year, the TGA published a position paper regarding the early publication of information regarding prescription medicine marketing authorisation applications in Australia. The position paper explains that the TGA is considering two options for an early notification scheme for new generic prescription medicines, with changes to potentially be implemented from early 2021. The first of the two options would require a generic to inform the relevant patentee that the generic has passed preliminary TGA assessment whenever it believes that a relevant patent is in existence, and that's regardless of the generic's views regarding infringement or validity of a patent. And the second option would require a generic to notify the originator that a generic has passed preliminary TGA assessment whenever it proposes to rely on information of another to support its marketing authorisation application. And this is regardless of the existence of any patents. The TGA suggests that preliminary assessment may occur up to about 10 months before the generic is actually entered onto the ARTG. At this stage, it's really a matter of keeping an eye out for any further developments in terms of those reforms. On that note, I do thank you for tuning in today, and it is now my pleasure to hand over to Claire Gregg and Sian Hope.
Good evening, everyone, and thank you for attending this seminar. My name is Sian Hope, and I'm a lawyer at Davies Collison Cave Law. Today, I'll be primarily discussing the novelty issues that arose in the recent case of Mylan Health and Sun Pharma, and my colleague Claire Gregg from Davies Collison Cave will be exploring the interesting issues in this decision that relate to the infringement of Swiss Style claims. By way of background, in this case, an enlarged bench of the full Federal Court of Australia unanimously rejected Mylan's appeal against the Federal Court's findings that 3 of Mylan's Australian lipidyl fenofibrate patents were invalid and therefore could not be infringed by Sun Pharma's proposed generic fenofibrate formulations. As you can see, the case provided some insight into when clinical hypotheses and clinical trials might destroy novelty. It included some comparative commentary regarding Europe's approach to these sort of patents, and finally, the court discussed the infringement of Swiss Style claims. The dispute related to 3 patents directed to fenofibrate and its use for the prevention and treatment of diabetic retinopathy. The 3 patents are set out on the slide, but essentially they're related to the manufacture and use of fenofibrate products sold by Mylan under the name Lipidyl. Diabetic retinopathy is caused by prolonged high blood glucose levels, which over time can ultimately result in vision loss. In 2019, Justice Nicholas of the Federal Court of Australia held that all 3 patents were invalid. Most relevantly to this presentation, however, His Honour found that the 711 patent was invalid on the basis of lack of novelty and inventive step. The trial judge found that the 711 patent lacked novelty in light of the Accord Eye study protocol. Essentially, this clinical trial protocol, amongst other hypotheses, predicted that using a fenofibrate treatment will reduce the development or progression of diabetic retinopathy. In essence, the relevant hypothesis expected exactly what was claimed by Mylan's 711 patent. Mylan argued that the aforementioned hypothesis was nothing more than a reasoned hypothesis, such that its disclosure, which had not yet been evaluated, could not constitute a clear, unmistakable direction to perform the method, couldn't teach the invention, and couldn't deprive the patent of novelty as an anticipatory disclosure. They contended further that the protocol merely taught the administration of fenofibrate for the purpose of evaluating its efficacy for the claimed therapeutic purpose, rather than making such a disclosure for the deliberate administration of fenofibrate for that purpose. The full court set out the leading authorities on novelty and went on to reject Mylan's submissions that a documentary disclosure containing hypothesis could not be an anticipatory disclosure and thus deprive an invention of novelty. At paragraph 83, the court reiterated that prior documentary disclosure will not be anticipatory if it merely provides information at a level of generality which, while encompassing that which is claimed as the invention, nevertheless fails to identify the invention with sufficient specificity. Their Honours did, however, clarify further at paragraph 87 of the judgment that even where the disclosing document is sufficiently specific, it might not go far enough to disclose all of the essential features of the invention. Ultimately, the court held that the question, simply put, remains, what does the prior document disclose, which is at paragraph 104. Their Honours went on to conclude at paragraph 105 that by proposing the study according to the protocol and its hypothesis, there was a disclosure that fenofibrate was to be deliberately administered with a statin with the aim of preventing or treating diabetic retinopathy in patients in need of such treatment. That is, plainly, the method of treatment that the Accord Protocol instructed practitioners to carry out, and therefore the Accord Protocol disclosed the claimed method. Their honours notably stressed that the validation of the hypothesis was certainly not required to constitute the requisite disclosure to deprive a patent of its novelty. The unanimous court therefore concluded that the primary judge did not err in his findings that the Accord Protocol deprived the 711 patent of its novelty. At trial, Sun Pharma also argued that the method of treatment claims of the 711 patent were not novel in light of two studies that allegedly used the claimed methods, the Accord study and the field study. The Accord study was that proposed by the Accord Protocol, and the field study was disclosed in the specification of the 711 patent. Justice Nicholas rejected this argument on the basis that the two clinical trials were double-blind studies, where neither the patient nor the researcher knew whether they were receiving or administering the fenofibrate or a placebo. And the full court said that they were inclined to the view that this challenge to novelty ought not fail simply because the studies were double-blind. Rather, they said the collective activity of the clinical trial could anticipate the claims, particularly when considered together with the knowledge of the aims and methods of the clinical trials. However, at paragraph 236, the enlarged bench concluded that they refrained from expressing a final view on the matter, and this was because of the limited attention that was paid to these grounds on appeal, and that they had already concluded that the primary judge did not err in his findings on novelty. Arguably, these comments indicate that Australian courts may take the view in future that double-blind clinical trials which utilise a claimed method could rob a patent of its novelty. Just briefly regarding inventive step, the full court essentially reiterated well-known principles. They confirmed that an assessment of inventive step involves a tricky evaluative judgment. The assessment may be aided by asking whether a person skilled in the art would be directly led as a matter of course to try the claimed invention in the expectation that it might well produce a useful or better alternative. This is the reformulated Cripps question. And this evaluative exercise does not require the court to form a view as to whether the person skilled in the art's expectation of success was better than 50-50 or otherwise assess the chances in terms of percentages. I just wanted to note at the end here that the full court did make some interesting comments comparing Australia and Europe's approaches to novelty considerations, particularly paragraph 111 of the judgment. Mylan sought guidance from European cases, in which the court actually did agree that they provided broad support for Mylan's position. So under the European Patent Convention 2000, Swiss type claims and purpose-limited product claims will not have their novelty destroyed merely by prior disclosure that a pharmaceutical compound or combination of compounds might have the therapeutic effect that the patent in suit claims for that compound or combination. In summary, European case law provides that the actual achievement of the therapeutic effect is a functional technical feature of the claim, as opposed to a mere statement of purpose or intention. Therefore, the claim is read as achieving the therapeutic effect. The claim imports an element of established efficacy, and in order to anticipate, the prior art must disclose the achievement of the therapeutic effect itself or a pharmacological effect directly and unambiguously underlying that therapeutic effect. However, in this full court case of Mylan, the court forthrightly rejected this European approach and concluded that the above principles are not the principles developed under Australian case law, as are applied in the cases of BMS and Faulding and Merck and Arrow. And just before I hand over to Claire, I'd like to note that the court did discuss the 807 patent in relation to inventive step, as Justice Nicholas found that the invention was obvious in view of the common general knowledge alone, but not when combined with a specific prior art document. And the 964 patent was the subject of a fair basis attack. However, the full court essentially reaffirmed well-established principles in this regard. So I'll now hand over to Claire to discuss the infringement aspects of the case.
Thank you, Sian. So although the claims of all three patents were ultimately found to be invalid, the full court nonetheless provided some useful guidance on the infringement of Swiss-style claims in the context of the 711 patent. So the question of infringement ultimately boiled down to Dependent Claim 5, which related to the use of fenofibrate in the manufacture of a medicament for the prevention or treatment of diabetic retinopathy in specific dosages. Diabetic retinopathy was included among the indications listed in the product information for Mylan's Lipidyl product on the ARTG. Mylan alleged that Sun Pharma, formerly Ranbaxy, threatened to infringe Claim 5 by listing its own fenofibrate products on the ARTG, having the dosages recited in Claim 5, the PI for which stated that they are bioequivalent to Lipidyl. However, while the Ranbaxy products were originally approved for the treatment of diabetic retinopathy, the PI was amended during the course of proceedings to remove any reference to diabetic retinopathy and specify only those indications listed on the screen. Sun Pharma also proffered undertakings that it would not market the Ranbaxy products for diabetic retinopathy while the patent was in force. So by way of background, the typical form of a Swiss-style claim is use of substance X in the manufacture of a medicament for the treatment of condition Y. Where substance X is already known, Swiss-style claims generally derive their patentability from the new therapeutic use of substance X. The use of the medicament as it emerges as a product of the manufacturing process for the treatment of condition Y, and this condition alone, defines the monopoly of a Swiss-style claim. Therefore, Swiss-style claims are properly characterised as purpose-limited process claims, but their monopoly does not extend to the actual use of the medicament in the treatment of condition Y. This is the realm of method of medical treatment claims. So although they originated in Europe to address specific patentability requirements under an earlier iteration of the European Patent Convention that did not apply in Australia, Swiss-style claims have nonetheless been widely adopted in Australia, as well as New Zealand, as a mechanism for protecting against manufacturers of competing pharmaceutical products, including products manufactured overseas and imported into Australia. In contrast, method of medical treatment claims are infringed by administration of the relevant pharmaceutical product. At first instance, Justice Nicholas considered that a Swiss-style claim imports a mental element with respect to the manufacturer's intention. As such, the relevant question in determining whether the Ranbaxy products infringe Claim 5 was whether the manufacturer objectively intended them to be used for the treatment of diabetic retinopathy. According to Justice Nicholas, the relevant factors to be taken into account in ascertaining the manufacturer's objective intention include the disclosure of the PI in any product labelling, as well as the nature, size, and pertinent characteristics of the market into which the product is to be sold. His Honour held that there was no threatened infringement of a valid Swiss-style claim of the patent because there was insufficient evidence to establish the objective intention of the manufacturer. However, Justice Nicholas did find that the corresponding method of treatment claims would have been indirectly infringed if valid, because it was reasonably foreseeable that a significant portion of the Ranbaxy products would nonetheless be used by medical practitioners for treating the same indications as Lipidyl, specifically diabetic retinopathy. So one of the grounds of appeal put forward by Mylan was that Justice Nicholas erred in finding that Swiss-style claims import a mental element on the part of the manufacturer. The full court agreed that the proper construction of Swiss-style claims does not involve the addition of a further essential feature, that being the manufacturer's objective intention. Rather, the relevant question is whether the medicament is for the specified therapeutic purpose. This is more than a mere suitability for use and instead requires consideration of a variety of factors depending on the specific circumstances of the case, no single one of which is determinative of infringement. So the factors that may be taken into account do include the manufacturer's intention in producing the medicament, but also its physical characteristics such as its formulation and dosage, the packaging, labelling and PI for the medicament, and the reasonably foreseeable uses to which the medicament would be put after its manufacture. So although the PI for the Ranbaxy product specified that it is bioequivalent to Lipidyl, the evidence established that there was a substantial therapeutic use for the Ranbaxy products in the treatment of the various disorders listed in the amended PI. The lack of a disclaimer in the amended PI for the use in treatment of diabetic retinopathy was not considered proof that the medicament is for that use. Ultimately, the full court did not consider that the facts pointed persuasively to a conclusion that the Ranbaxy products are medicaments for the treatment of diabetic retinopathy, and hence there would be no threatened infringement of Claim 5 if valid. Mylan also contended that the primary judge's finding of non-infringement of the Swiss-style claim was inconsistent with the finding of indirect infringement in relation to the method of treatment claims. However, the full court rejected this submission on the basis that different considerations inform the question of infringement in each case. The question of indirect infringement of the method of treatment claims turned on whether it was reasonably foreseeable that a medical practitioner would prescribe the Ranbaxy products for diabetic retinopathy. In particular, the court accepted at first instance and affirmed on appeal that medical practitioners do not typically prohibit the supply of generics on prescriptions and do not typically read the PI for a generic product, but assume that the indications for the generic will be identical to the originated drug unless any differences are specifically drawn to their attention. In any case, the PI for the Ranbaxy product says they are bioequivalent to Lipidyl and does not state any reason why they can't be used to treat or prevent diabetic retinopathy. Therefore, even if not manufactured for the treatment of diabetic retinopathy in a manner that would infringe the Swiss-style claims, it was still considered reasonably foreseeable that the Ranbaxy products would be used by medical practitioners for this purpose after they were manufactured, hence the finding of indirect infringement of the method of treatment claims. However, this was ultimately irrelevant for present purposes, since the claims were found to be invalid for lack of novelty and inventive step, as outlined by Sian. So to summarise the key take-home points from this case, Swiss-style claims are only infringed if the resulting medicament is for the claimed therapeutic use. The manufacturer's objective intention is not determinative of infringement, and if the alleged infringing product is presented to the market for a therapeutic use not covered by the patent, it may be difficult to establish infringement. Further, when filing a pharmaceutical patent in Australia, it's advisable to include both method of treatment and Swiss-style claims to provide the broader scope of protection against potential infringers. Finally, a patent application should be filed before publishing any clinical trial protocols or conducting those trials, as this case demonstrates that a reason hypothesis or double-blind clinical trials can be novelty destroying. An invention may also be considered obvious if a skilled person would be directly led to try it in the expectation that it might well produce a useful result, even if the result or outcome is not certain, and a percentage-based analysis will not be of assistance in this case. That all being said, it should be noted that Mylan has filed an application for special leave to appeal this decision to the High Court, which is Australia's highest appellate court. So there is a possibility that this position will change in future, and we will definitely let you know if it does. So that's it from me. Thank you all for your time, and Sian and I would both be happy to answer any questions you may have.